Welcome back to the Create Brand Envy podcast. Today's episode is for anyone who creates for a living. Whether you're an agency owner, a designer, a marketer, a writer, a strategist, an entrepreneur, or even just any kind of brand leader who's turning ideas into real business value. Because your ideas are your business. Your process, your strategy, your creative work, your brand, your content, your client relationships, all of these things carry value. But if you do not understand how to protect them, price them, license them, or clearly communicate ownership around them, you may be giving away more than you realize. In this episode, we're going to be talking about intellectual property, contracts, source files, trademarks, artificial intelligence, which we're all using to create things, right? There's some caveats there. Licensing, ownership, and the real world issues creative businesses are facing when ideas can become assets. This conversation is meant to empower you because protecting your work will help you build a business that can grow, sustain itself financially, and continue creating for many, many years to come with confidence, but more importantly, profits. So as you listen, I hope this episode helps you think more deeply about what you create, what you own, what you share, and what deserves to be protected. Let's get into it. Today's guest is Sharon Toerek, a marketing and intellectual property attorney who works with agencies across the U.S., helping them protect what they create and structure smarter client relationships. She's the founder of Legal and Creative and the host of the Innovative Agency podcast. In this conversation, Sharon will shed some light on the complex world of protecting creations of the mind, otherwise known as intellectual property. Because whether you're a creative, agency owner, or a brand leader, no matter what you're creating, your ideas are your business. Sharon, thank you so much for joining me today. I'm excited to learn more and break down, the critical world of protecting your intellectual property and actually making money off of it. So thank you
Thanks,
for being
Nicole.
on.
No, it's my pleasure. Thanks for having me. I'm looking forward to our conversation.
And today's a special episode because for the first time ever, we have a special guest, Maria Daly. Maria has been with Brand Envy for 10 years, which is remarkable. And we made sure we celebrated and her tenure in grand style. We're very appreciative. I thought to bring her on because behind every creative person, there's a analytical, highly organized, highly, intellectual, mathematically smart person clicking the gears and making everything work. And for me, that person is Maria. Maria, prepare to be poached. Say no to everybody, okay?
Very happy of Brand Envy.
Happy anniversary, Maria.
Thank you. Thank you.
And since this episode has to do with contracts and client relationships, I thought she would be a wonderful addition to add a little bit of insight. So welcome, Maria.
Thank you. Very excited to be on.
All right, Sharon, let's dig in. Okay, what is intellectual property?
It can be a lot of different things. Really, there are many categories of it, and intellectual property is really the product of your creativity and your ingenuity or your innovation, and it can be expressed either in the form of the way you brand your product or your services. It can be expressed in some sort of what we call manifestation, some physical expression of originality, which is what the copyright law is designed to protect. It can be a novel invention, which is what patents are typically protective of. It can be a trade secret, which is information that provides your business a competitive advantage merely by the fact that it's been protected and preserved as confidential within your business and because it gives you some sort of leg up on your competition. It's a unique way of doing things, or it can be a client list, it can be a knowledge base. There are lots of ways to have trade secrets, but what they all have in common is they're valuable to you because they're confidential.
That reminds me immediately of the Coca-Cola formula.
Right. Yeah. I mean, Coke, that's an awesome example of a multi-billion-dollar enterprise built on the foundation of intellectual property, none of which is really patent protected. I mean, I'm sure Coke owns patents on some things, but the original formula of Coca-Cola has never been one of them, and it's a trade secret. And the only way it has been able to remain a competitive advantage and evolve privately over time is because of its status as a trade secret. And it's a brand, right? It's world renowned and time tested. And Coke's IP portfolio is so broad that it even extends to its packaging designs, and its
Color, Coca-Cola Red.
its taglines. There's IP in its marketing and advertising campaigns. It's a cultural icon in addition to being really a combination of multiple different kinds of intellectual property.
Yeah. And last night I was watching the Hulk Hogan documentary on Netflix, and he was talking about how being the wrestler paled in comparison to the money that was to be had in the branding and all of the merchandising that came behind. So, I mean, it's certainly significant. I know of a ton of people with great creative ideas or, great work products, and they struggle financially, right? So this conversation, I hope, is going to shed some light to anybody that's in the creative space that is either, producing one-time work product, intellectual work products or ongoing. How do we need to be thinking about creating our contract structures so that we can actually become wealthy off of those intellectual, opportunities, as opposed to, that struggling artist, so to speak.
Right. I think it actually takes place a step prior to that. I mean, smart contracts are one part of it, but the rubric we sort of use to look at intellectual property for a business, our clients happen to be in a particular industry, but this is certainly applicable to any sort of knowledge-based business out there, or any creativity or ingenuity-based business, is you have to look at it. We use a triangle as an example. You've got brand, which is typically trademark protected. You've got your content, which might be a trade secret or it might be something that's copyright protectable. And then you have your transactions, and contracts are one of the vehicles we use to reflect the transactions that protect intellectual property. And it's important because you want to make certain that your company's relationships with its clients, its customers, are adequately protective of your intellectual property. And you also want to make sure that if you've engaged folks outside of your company to help you create or execute your intellectual property. We mentioned the importance of execution earlier when you were introducing Maria, and IP is only as valuable as the revenue you can extract from it, right? I mean, it has value in other ways in society, but in business, we measure its value and its worth by how we turn it into revenue, and contracts are the vehicle for doing that. And so transactions is that third point of the triangle for IP protection. So before you get to the contract, you want to recognize the IP that you have, sort of categorize it, determine how you need to think about protecting it before you start worrying about how you're selling it to others versus maybe licensing it or loaning it in a way that allows you to preserve it but still make money from it, revenue from it.
Okay. So explain that. Explain the difference between ownership, licensing, and getting paid properly.
Right. So in a typical, what we'll call work for hire construct between a business like a marketing agency or a consulting firm or an architecture firm, the old construct was you customer are engaging us, the business, for a specific output, for stuff. And that stuff is going to consist of some probably physical or electronic deliverable. But the basis of that deliverable was the knowledge of the unique systems, process, methods, whatever it is that is our intellectual property as a business. We needed that to put it together. You get the deliverable, and in the old school way of doing it was you get the deliverable and the parties don't really think about the underlying IP. And so it became a problem whenever the client wanted source files, or they wanted the secret sauce at how you arrived at the deliverable. Those are things that your business needs on repeat to replicate results for other clients and customers. So you need to distinguish in your agreements and your relationships with these clients what they're buying and getting and what you are retaining. And whatever you're retaining as a business, you're licensing. You're lending it, you're licensing it. There's lots of different legal terms we could use, but for the purposes of our conversation, you are giving them the limited ability to use that IP as it's reflected in whatever assignment or deliverable you did for them, not the IP itself. And your contract needs to be reflective of that. So I would say that's the starting point is first of all, it's the thing between the ears, the way we think about it, right? Because I find that a lot of service companies don't really lead with the value that's in that IP. They don't think about it every day. It's just, it's part of what we do and get paid for. And we're not going to be too precious about it because it's not how we make our money. When really it is how you make your money. It's just that you haven't been used to the vocabulary of talking about it that way with your clients and customers.
So how would you advise somebody? So, you mentioned the source files, and immediately I'm having, of course, a ton of memories. We've been in
Yeah,
business for
it's
over 16 years where
a little
clients
bit of
go,
PTSD about that.
totally. I think you saw, if you're looking at the video, by the way, if you're listening on, your favorite listening podcast, you can also watch the video. Yeah. And you can see our facial expressions.
Yeah.
Maria flinched a little bit. I kind of went like, totally. Definitely, ruined relation. So there's two spectrums that I want to kind of ask you about. Like, so on one end, we once hired an attorney to prepare our contracts because I wanted to make sure that we were nice and tight. I love to run a tight ship. I like to do things correctly. And so he prepared a contract. And what happened is that nobody would sign it because it was, like basically what we were going to do for the client. And then maybe 3 or 4 pages of like 2 columns of fine print in this, justified, like it was a contract. And so my clients that I tried to convert them to sign that, they're like, I'm not going to sign that. First of all, I'm not going to read this. I'm not going to pay my attorney to read it for me. And I'm just not going to sign it. And so nobody would sign it. And then go ahead.
No, I hear you. What? Keep going.
No, and then on the other side of the spectrum, and I think I might have lost my train of thought for a second after I was remembering that moment. But on the other side of the spectrum, there's cases where, clients will ask us for the native files or, pictures that weren't used or video footage that wasn't used or the raw video footage or something like that. It becomes kind of like a little contentious, it kind of damages the relationship. And so how would you advise proceeding, right? Like kind of in the middle, right? Like not on one end, like where is that middle point, Sharon?
Right. Well, I think every business's contracts with its clients should be written in a way that is clear, understandable, which is not the same as always 100% comfortable for your client or your customer. And I don't think you should be shy as a business about defending protective language in your agreements. Now, if it's so dense that nobody really knows what it means or why you're signing it, that's a communication issue. And I think that's a contract drafting problem in general, unrelated to IP, but it can hang you up here because if it's so dense that nobody's really reading it or understanding it, then the message can get buried. And the message needs to be, and it starts before your contract. It starts maybe in the proposal or the estimating phase of the work. It starts with you distinguishing as a business between what the client receives and what the business selling the service is retaining. So, an example, we're using our proprietary XYZ method to deliver to you the ABC thing, whatever it might be. Let's use the architecture example again. We're going to deliver you a set of blueprints and engineering drawings, and we're using our proprietary methodology for, developing floor plans or whatever it might be. You don't get our proprietary methodologies. What you get is the one set of blueprints that we had to use our IP to create for you. And so that's always ours. We use it for other clients too. You get the blueprints. That's it. That's a conversation that occurs way before the parties should be signing the contract. So I think
Right.
this is as much a communication challenge as it is a legal drafting challenge. But, if a business is moving forward with a client with language on any point, whether it's IP ownership or any other part of the business relationship, that it can't easily explain or answer questions about, then I agree with you, Nicole, that you need to go back to the drawing board and come up with language that is protective, but that is understandable and explainable. And that's not the same as saying the contract should only be 1 or 2 pages. Trust me, I've had this conversation for years, especially in our client industry. Marketing agencies hate long contracts. And my response to them is always it's going to be as long as it needs to be for us to be comfortable protecting you. If it's that you don't understand it or we need to use different language, we can have that conversation, but I don't ever limit myself. We like a contract to be as protective of the client as it needs to be. And so when it comes to intellectual property, it is all about segregating out what the client gets, what the seller's retaining, and also whatever third party intellectual property is being used. If you are, let's use the example in marketing of stock photography or stock video or stock font or software. If you are using those underlying pieces of intellectual property that some third party created, it's not you, it's not your client, nobody owns those. You're all licensing them, right?
Mm-hmm.
If you're using AI to generate any part of the work product, no one can own the output of a machine. And so that needs to be called out now increasingly in agreement. So being thorough is not the same as being confusing, but you do need to be thorough.
Yep. And so if I'm a creative, how would you advise me, and just a creative in general, right? How would you advise me about protecting my work? Let's just pick an example. And when should I choose to own and when should I choose to license? I think a good example is, I don't know if you've heard of Jason Weaver. He's the voice of the Lion King, Little Simba in the original, the 90s. His story is that Disney wanted to provide him with, I think, $100,000 payout up front, but his mother negotiated for just licensing and receiving royalties. And it's a famous story now because obviously, over the years, he's made well over $100,000, closer to the 2 million mark. And I think it's a good case study of, deciding how am I going to monetize my creative work. So how would you advise somebody to structure those deals?
Right. That one's a little bit of an outlier for most businesses, I think, because it's in an entertainment based example.
Hmm.
But I think we can pull some threads from there into any creative business. And that is, I think you have to understand what your risk tolerance is for, earning the revenue today versus the promise of more revenue or ongoing revenue in the future. That's the first thing. And they made a specific bet that could have gone either way, quite frankly, depending on how that particular entertainment vehicle performed. Let's take because there are marketing agencies who are doing this now with some of the campaign work they're doing for brands. And this is also a relatable example when it comes to using influencers or creators in your marketing. And so there you're negotiating you have to decide as the creator, do you want to create something and sell it outright for a guaranteed level of compensation today? Or are you taking the long view and licensing it, lending it basically to the user for a particular period of time or for a particular person? For example, in the example you cited, he could have just given them the rights to use the voice in the movie, but not in commercials or not in other applications. And so, and then you create the business arrangement and the reflective contract accordingly. So that's as much about what is your risk tolerance as a business owner and an entrepreneur around your IP. Do you want your money now or are you willing to play the long game? And then you make the arrangement accordingly. Anything less than an outright transfer of the rights is a license of some sort. You can call it something different. You can call it a royalty arrangement. You can call it, but it's a license because you are allowing somebody to use something you've created for a time certain or a specific reason, and you're holding back the ability to allow others to use it in other ways, shapes, and forms.
Okay. And in terms of reality, right? So like a contract is just words on paper. A contract needs to be enforced or not enforced. Can you speak to that a little bit?
Well, you're right. Contract is designed to be a roadmap between two people or two entities about how their business relationship is going to progress and what the rules of the road will be for sorting through any misunderstandings or failure of minds to meet, right? So if you're unwilling to, if someone is behaving badly in that relationship, and in this example, it might be misusing your intellectual property, right? Or it might be not paying you for the intellectual property that you've created for them as they've agreed to do. Your ability to use the contract as a tool to protect yourself is only as useful as your fortitude, right? Your willingness to hold people accountable for their behavior. And so there's an expense to that. So IP enforcement is continual. It doesn't just start when you're registering a trademark or registering a copyright or putting together a contract. It starts then, and you carry it through in your negotiations with the other party, and you carry it through when things aren't going according to plan. And so it is a lifelong commitment to protecting, preserving, and taking action. Because if you don't protect your intellectual property, you may lose your ability to protect your intellectual property. That can be used against you in
Can you explain
later
that a little
situations.
bit better?
Yeah, if you fail to act upon somebody infringing on, if you know somebody's infringing your copyright, or if you know somebody's infringing your trademark, um, or if you know that somebody has received the benefit of something you've created for them and not paid you for it, and you have the right language in your agreement, and you don't take action on that, and it happens again with somebody else, they can use that failure to enforce to push back and say, you haven't enforced this in the past. Why
Right.
should we agree to allow you to enforce it against us? And then it just creates enforcement issues for the owner of the IP. So you want to be consistent and protective, and it's a lifelong commitment, or at least it lasts the life of the intellectual property. And some IP can last forever as long as you maintain it. So that's not something a lot of entrepreneurs enjoy hearing because it doesn't feel fair. I get that, right? We've created it. It was our brainchild. We took the time to enter into an agreement that everybody agreed was fair. And now they're not abiding by it, and that's going to cost us even more money, time, lost opportunity. And that is just part of the cost of leveraging IP for financial gain.
And so that doesn't matter. Like, I can imagine a situation where someone keeps something or uses something that's pretty small. So you're like, oh, I'm gonna let that go. But that the comparison between the one you would enforce and the one you don't doesn't matter. One's tiny, one's a much bigger cost to you. You could get dinged for not enforcing the first one.
Yeah, well, and yes, it's going to be used defensively, first of all, and second of all, success or failure both leave clues, right? If you haven't enforced it in the past, what's the likelihood that you've taken the steps to allow you to enforce it the next time this happens? And what I like to say is that this is all about putting the process in place proactively. I think legal affairs, and this is one example of them, legal affairs in creative business should be a profit center for you. And one way they're a profit center for you is having good protective contract language in place and having good protective IP protection strategies in place so that you have options later. You may choose not to enforce. That's a perfectly valid and legitimate business decision, but make it with intent, right? Not because you don't have options available to you.
I have a good story. I'm not going to be specific, right? I don't want to, reveal personal information, but There was a client a potential new client that contacted me about helping them rebrand their retail store. And I asked him, why do you want to rebrand? Right? Essential question. He goes, well, I've been served the cease and desist. I have to change my whole branding. And I'm like, why? And he says, well, there's another retail type establishment, very tiny, actually. Think of a hot dog stand type establishment that in a completely different state that filed all of the trademarks and protection for that brand name, and it's in the same industry and category as me, and they're about to be featured on like the Food Network or some kind of major network, so they're now doing their due diligence to make sure that there's nothing else like that, whatever, and that I'm fully whatever. And so they have sent me, before they go live on national TV, they need me to shut down basically. And I remember thinking, oh my God, because the cost of a rebranding, people sometimes they start their company, they're like, oh, I'll have my niece do the logo. Like they don't understand that downward effect. When you talk about rebranding, we're talking lots and lots and lots of money. Obviously, if you're big and successful, right? If you're just like a rinky dinky one man shop, I guess it's not a big deal, but
Yeah. This is such a heartbreaking story, and we have seen this time and time again, honestly. I actually started my IP career as a trademark lawyer, and so that's kind of close to my heart. And failing to do or shortchanging your trademark due diligence. Trademarks are a key piece of intellectual property for every kind of business, and skipping steps are misunderstanding the clearance process for such a major piece of your intellectual property as your brand. Those are the stories that break your heart about either after having sunk money into developing goodwill behind a name for your business,
yes,
only to learn that you've been in conflict all along and maybe you didn't know it, but now you know it and you can't avoid it. We've got stories of folks who've gone down the branding pathway and spent a lot of money to start executing on a brand that they love, and then finding out before they go full public that it's going to be a problem for them, and they've thrown all that money away because they didn't do the due diligence and the clearance early enough in the process. Or folks who don't understand that brands are category specific, and so that you need to understand that before you adopt one in connection with your business. It can be a marketing hassle, it's definitely a money hassle, and it's a trademark hassle. And so I think that, and the challenge again with AI, I hate to keep waving it into the conversation, but
we're going to talk about AI next.
Yeah.
So
awesome.
You're good.
Well, this might be a good segue into it. But the challenge with AI is the abundance of information without context, the abundance of information available without the ability to adequately interpret what it can mean for you and your business legally, as particularly with the amount of IP creation that you could think you're doing with the machines that may result in nothing but a legal problem for you, whether it's
Yes.
on copyright or the trademark point of view.
Yes. Okay. So let's just dive into that. Everybody is using AI, whether it be, our infamous ChatGPT, our Claudes. There's also image generation. You mentioned photography earlier, and I was reading about how, photography is taking a big hit because people can upload a reference image and just generate a perfectly good stock image. I myself have debated this, and I've talked about it in previous episodes about what qualifies as original work when AI is involved. Because, and I'm going to focus more on the writing aspect. It's like I understand, like I am being helped by AI, but I'm still the one kind of driving the truck, so to speak. And whenever it kind of veers off track, I'm the one who's, corralling it. And if I assigned Nicole, Maria, and Sharon to produce an article about whatever, our work product, even though we're all using AI, is going to be vastly different because we are the ones who are really, like I said, driving. So I'm confused. I would love your insight as to what qualifies as original work if AI is involved. Where are the lines?
Well, the way that copyright law stands in the United States right now, actually in most Western countries, but definitely in the US, is nothing that is machine generated can be copyright protected. So what you're left with then as a creator, and in your case, and in the case of many of our clients, as a creator of marketing or advertising strategies or materials, is when it's a hybrid work, you might have used AI for part of it, and humans may have contributed, evolved. You left with a work that is a combination of AI generated stuff and human created content. And the challenge becomes, can you separate part A from part B? Are you able to, because you're only going to be able to own and convey to your clients and customers whatever has been human created. And so what that ends up meaning is the need to document your processes well, so you can tell the story about how a piece of work evolved and what humans contributed to it versus what was generated out of the machine, which isn't protectable. And that's part of the story. The second part of the story is who's responsible for that once it gets out into the world. Let's see a piece of work is launched publicly, which is the goal, right? With the work that you're doing for them. You want them to be able to use it in their business. The answer to that right now is if it's infringed on some other third party's copyright, or if it's created some sort of other legal issue. For example, there's an inaccurate product claim in it, or there is a misuse of somebody's likeness or image, or there's a misuse of a trademark that looks close to somebody else's trademark. Who's legally responsible for all that? Right now is that everybody needs to be concerned about that. And it's not going to be the AI platforms that the output shot out of. They're very clear in their terms and conditions that they're assuming no responsibility. So it's the creator and it's your client who is ultimately the brand holder. And then the two of you are going to have to figure out in your contracts how you're going to allocate the liability and the responsibility between the two of you if something goes sideways. So the shorter answer is you can only own what you can prove was human created. How do you do that? You have to document very carefully what the AI output was and what humans did to it.
I'm shaking my head because I'm like that
I
just
know
feels like an
creators aren't doing this.
impossibility.
No,
How can you?
it's
Well, I'm thinking of people that if you hire a contractor to help you do something and then you're utilizing that, then you're assuming that their work was all human. Like, where's the line of like who, as work gets passed along, and who owns that piece and whose responsibility it is to tell the next piece that they did use AI and how much AI they used.
right. You really do have to work it back from the commitments you've made in your contract with your client, first of all, about AI, particularly generative AI, right? Because that tends to be what people are most concerned about initially, is if you've used generative AI to create the work you're turning over to us, how do we know it doesn't infringe on anybody else's work? And how do we know what's ownable? And sometimes, honestly, and do we care? Right? If it's work that's going to exist for a season or a reason and not live for the long haul, maybe the parties don't really care about the ownership piece of it, but they certainly care about the infringement piece of it. If some third party comes calling to say, hey, your campaign looks exactly like something that, we've created. And the challenge is it's not knowable, right? The platforms are certainly not going to tell you that they've fed in some copyright protected work into their training data. Everyone's sort of having to figure it out on the fly. There's no case law that's going to protect the creator for the time being and or hold the AI purveyors responsible legally for any infringement that occurs. So you just kind of have to be very open in your conversations with your clients. We start there, right? And then you're absolutely right, Maria. To the extent you're using freelance or contractor talent, whether it's an individual or another company you're bringing into the process, you need to know what their practices are around using AI generatively so that whatever commitments you've made to the client flow through in your agreements with those folks so that the IP can all flow the way it's supposed to and the liability and the responsibility stays where it is supposed to, as the case may be. So it's really complex, and I don't blame the average creative or innovative company for being frustrated at how difficult it can seem. All you can do is be proactive in addressing it in your contract language, in your internal and your external policies about how you're using AI, and careful conversations with all parties concerned about the IP issues associated and any other liability or legal, jeopardy that might be created by using AI. Because, the train has left the station. We're not going to stop using these tools, right?
Right.
To either figure it out or have an understanding of the level of risk we're actually assuming.
Are the issues more around create like graphic photography versus the written word, or is it similar across both? Or is it going to become similar across both, I guess?
I think it's similar. I think our natural inclination in creative services fields is that it's image use, right? Because that covers both potentially trademark and copyright conflicts. But it's definitely a problem with the written word because we know for a fact, and the AI platforms have been, well, I'm not going to say they're transparent about it. I'm going to say they're public about it because in many cases they've been outed. But we know for a fact that their training data includes copyright owned work that was just either flat out stolen or acquired under shaky circumstances and fed in. And there's no way for you to know as a user of these tools what output that whether the output that you're getting contains any of this protected work. You don't know for sure.
Yep. And even I feel comfortable sharing. I'm not going to say specifics, but I feel comfortable sharing the story. It was a blooper of ours, and not a blooper. It helped us refine the way we do things, but it applies the same to AI as well as like human error. Way back when, way before AI, we worked on a logo project that we presented some samples to the client. She picked one that she really liked. And then we started working on refining that. And a lot of the refinements came from the client. She's like, move this at an angle, put this here, change the colors to be this, change the, nudge this, nudge that. It's like, there's a point in the creative process where you're like, sure, client, whatever. Like, let's just get the project done.
Yeah.
And I always thought that they were like innocuous changes. Like it didn't really matter. It was like, okay, whatever. We ended up finalizing and packaging the logo. And then, moving on to the next project. One day I'm on LinkedIn, just casually browsing, and I see an ad, a little icon, and I go, gosh, that looks a lot like the logo we just created for this client. Like, that's so weird. So I click and I look, and I cannot remember if it was in the same industry or not. By the way, we've mentioned the industries before for those who don't know, like, so there's Delta Faucets and Delta Airlines. Well, there's no problem there because you don't confuse Delta
Right.
Faucets with Delta Airlines. But if
Trademarks
it was
are category specific, correct?
exactly,
Yeah.
exactly. So I can't remember that detail, but I do know that I took a screenshot. I approached my client and I said, look, we went through, like, I don't know how this happened, but I wanted to let you know this happened. And then of course I went through, you talked about documenting the creative process, which at first I'm kind of like, how would you even do that? But we did. We had like everything was via email. We had PowerPoints of all the different back and forth, her sketching what she wanted. So I was able to kind of prove back to the client, like, hey, this was a genuine accident. Like you kind of nudged it in that direction and it looks almost identical to this other company's logo. Unfortunately, I think we need to kind of go back to the drawing board. But it makes me think of like, whether an AI was borrowing ideas, right, from copyrighted material, or, maybe she subconsciously nudged it in that direction. Like, what happens in cases like that where you accidentally end up with a work product that is violating and
Yeah. So the funny thing about logos is that they can serve as both trademarks and they might be copyright protectable because they are original artistic expressions, right? In many ways. And so I would say from a trademark perspective, in that example, the risk feels low if the two users are in completely different industries. From the copyright perspective, it all comes down to access and substantial similarity. Those are the elements of copyright infringement that are the most important ones. So, access, what does that mean? Did you actually see this other mark and know about it before you went public with your own? And substantial similarity, are they so similar to each other that they might be likely to, be perceived as the same? And there's also a concept in trademark law called likelihood of confusion, which is the number one reason why a trademark fails, is because it is likely to cause confusion between two brands, right? So you got your trademark review and your copyright review, and you didn't mention, Nicole, whether that happened before you went public, but if that was presented to me and there was an opportunity to pull back before going public with a new brand, that's probably with these limited facts, how we would probably tell our client to proceed. If you've already launched and it's completely coincidental and innocent, it's probably not a trademark problem. Whether or not and it's probably not a copyright problem. It's probably just a bad coincidence. And those do happen, and they did happen even pre-AI. Every once in a while, there were always like logo inspiration websites that agencies or artists could go to get ideas. And we certainly saw a few of those cases over the years where, a new brand looked kind of suspiciously like something that was on one of these inspiration websites. And was it a trademark problem? Maybe not. Could it have been a copyright problem? Maybe. So it's highly fact specific, but AI has just created so much more real estate for these types of conflicts to occur, and for something truly original, something that feels truly authentic and original to be developed. And so you just have to be really careful about the way you're documenting your processes as creators, because that is the only way to really establish the human in the loop, right? In terms of ingenuity and creativity.
And what happens, this is a little segue, but when you are pulling from AI, like generative AI, people's faces, for example, like in terms of,
Right.
we use stock photography a lot, and it has people in it. And so your sort of assumption, if you're doing generative AI, is that those are being pulled from stock photos of people's faces that there's permission to use. But I guess we don't actually know that.
You should never assume that. You should never assume that an image taken that's generated out of AI is available for a commercial purpose, right? And we have to remember that at the end of the day, if we're creating work that's being used to sell something or promote something, that is a commercial purpose. And we have much less latitude to get away with that or not be liable for violating somebody else's rights. Name, image, likeness is an area of IP we didn't really talk about, but it is the ability to control the use of your likeness, your name, your face, your voice for a commercial purpose. AI creates tons of opportunities. I am really frightened for, and this is going to maybe sound archaic to some folks listening, I am really frightened for people who just put their images into AI, to create, I mean, you can create a massive amount of good looking content, right? Video, audio that sounds and looks just like you, but then you lose the ability to control the use of your own name, image, and likeness over the long haul. So if you're going to a stock photography site where you are paying for an image and it has a human in it, that human, those services are not going to put those images up there if they don't have a sign off or a release from that model, right? That's a model release. If you've pulled it off of AI, you have no idea what its provenance is, and you cannot assume that you're legally in the clear to take it and adopt it.
And you bring up an interesting point. So, if I'm just playing with AI for my own personal, making something silly for my kids, or, with my likeness, with their voice, is that then potentially out there in the AI ether for someone else to use? And have I sort of granted permission for that picture to be used to
I'm
someone
not going
else
to.
by putting it out there?
You haven't granted permission, but you've granted opportunity by putting it in there.
Because that becomes data that points in that the AI is scraping.
It's part of the training data. I mean, particularly if you're using the unpaid and free versions of actually any AI platform, definitely Chat, GPT, Claude. If you're using those free, we're the product. So you are basically giving the platforms free reign to spit that stuff out in response to whatever prompts generate it. So Can you be sure of where your kid's picture or your picture are going to end up?
Yeah.
You can't. And, there's just as much an ethical or a moral question as it is an IP question. But the
Yeah. No, I
IP,
mean, it's scary.
yeah, it is. It is. And I say the IP answer for anybody watching this, and assuming you're all running businesses that leverage creativity in some way, shape, or form, never presume that an image that is generated out of an AI platform is available for commercial use. You're simply never safe doing that.
Boy, boy, oh boy.
Yeah, I mean,
We have a
you have to balance the risk with the opportunity. It's created, like I said, a ton of real estate, by which I mean opportunity to do things better, faster, cheaper, probably. But you have to balance the risks that go along with that and decide how much risk you're willing to assume, or you're comfortable with assuming, and also communicate about the risks with your team members, your contractors, your clients, and customers.
Yep, yep. And by the way, we for our clients at the agency, we keep tabs on their AI presence. And we can sit down and we can read every instance that our client's name was mentioned in an AI response. And we can also read the question that was asked prior to that response being given where our client's name was included. So, and same thing, I'm actually I'm not ashamed to admit, this is all like so new. We're all still learning about it. I would imagine that this is mostly coming from that free unpaid version of these softwares. I'm hoping, praying to God,
Well, I
the
mean,
paid
that
ones are
information, that's
private.
powerful data for you, and that's powerful data for your client to
Yeah.
understand the kinds of questions are leading people to your clients as potential resources or vendors. That's not in and of its, that's not evil. It's not bad. It just means that you need to be thoughtful about what you're feeding in
Mm-hmm.
and about your strategies for using whatever output comes from these tools when your team
Mm-hmm.
members are using them to create deliverables. We're all trying, or most of us are trying to do the right thing, right? We don't want to infringe on other people's rights or intellectual property or cause confusion in the marketplace. We're not doing this intentionally. It's just reflective of a need for training about what is intellectual property, what does it mean? What do we care about protecting? Because as I said earlier, just because something is ownable doesn't mean you need to care about owning it. It's a business decision as much as it is a legal decision. And then communicating what the rules of the road and what the understanding is around it. And we haven't even talked about, and we probably don't have time to thoroughly dive into it, but one of the huge vulnerabilities for using AI, if you are a firm that is, creative based or ingenuity based, is inputting data into prompts that could be confidential or proprietary,
Mm,
either
Yes.
to your company or to your client's company. You've got to be super, super careful about what you're inputting. You do not want to be using a business plan that discusses a new product release or feeding in your client's customer roster, or there's just a million use cases. Like I said, we don't have time to do a deep dive, but remember that using AI is as much about being certain you're protecting confidential information, including trade secrets, which is a kind of IP, as it is about owning and protecting the output from AI.
I think that AI is new, AI is going super fast. I think that everybody has really high hopes for what AI is going to be able to do for us. But more and more, I'm starting to feel like this sense that, again, I don't want to seem like, anti the future or whatever, but more and more I feel very like hesitant about, is it really helpful? Is it maybe doing more harm than good? Sometimes I find myself like, chatting with ChatGPT and I have to bracket it in so much that I'm like, I just feel like I would have been more efficient if I would just done this myself to begin with. I think we have too high hopes of what AI can do for us.
Yeah, I
And it sounds now like it's capable of getting us into a whole lot of trouble.
well, and I don't lay those risks out as reasons to stay
Not
away
using it.
from
Yeah.
using AI.
right.
I
But to
really
be
don't.
cognizant of.
We're actually very pro AI at my firm. I see a lot of use cases that are good and valuable for business, But yeah, there are moral and ethical questions about what it's going to mean for the number of team members that we have in our businesses. There are questions about authenticity and, effectiveness of the work that we're creating. If it all starts to sound and look the same, is it going to persuade anybody to buy anything or take any action? Or are people going to have trust in brands, right? If what they're putting out there doesn't feel like it's made by humans or for humans. And so, I'm not an ethicist and these are not necessarily legal questions, but they're, I think, things we're going to wrestle with as we figure out the short term problem of how do we stay out of legal trouble if we're going to use these tools? And how do we do that while not looking like we're holding our businesses or our team members back from keeping pace with what the rest of the market is doing? Entrepreneurship is not for the faint of heart, no matter what kind of business you own. And these are the kinds of questions that have always kept business owners up at night. The problem is this is a technological revolution that is moving faster than any of the other ones that we've seen in our careers. Looking across the board and kind of just generally gauging the generations we all fit into. I'm sure that people felt this way with the advent of cell phone technology and the advent of the internet. And the problem is this is moving so much more quickly than that ever did. And we are all just trying to keep our head above water here, right? And figure out how to stay out of trouble, maximize the economic upside, and do some good along the way.
You mentioned current law when you were speaking earlier. Is there any lobbying or anything going on in terms of like lawmakers to protect this topic when it
Well,
comes to AI and creative work products?
yeah, there are cases making their way through what I'll call the high courts. There's nothing in front of the Supreme Court currently that I think will be relevant to anything we've talked about. But there are high court cases at the appellate level mostly regarding the liability of these big AI purveyors for copyright infringement. If something that comes out of the output side, infringes on somebody's rights, would they have any responsibility? And also, can they continue to take content basically and plug it into their training data without compensating the original owners of that content? So those things are, moving at a glacial pace. Can you tell I just saw Devil Wears Prada 2 over the weekend?
Is it
Awesome, by the
good?
way, if anybody hasn't seen it,
Okay, good to
time
Oh,
know.
good.
this comes out, watch it or catch it on Netflix. But in terms of legislation, what we're seeing is kind of like what we see with data privacy, which is that it's a state by state approach in the United States, which means that we are all having to think about how to comply with 50 different sets of rules, just like with data privacy. Like I said, there's no federal statute with data privacy, although there's starting to be conversation around finally having a federal standard. With AI, it is the same, with the additional complication that you have the federal government saying to the states, we don't want you to regulate AI. If it's going to get regulated, we're going to do it, which probably means they're not going to do it and they don't want the states to do it either. But in the meanwhile, there are some state specific approaches that marketers need to be aware of. New York has definite laws around disclosure and use of synthetic performances in advertising. California has some specific rules. And then if you're using AI to process information, which almost all of us are, you need to be aware of the data privacy rules in all the states. And using California as kind of your guide is always kind of the safe bet there because they're the most restrictive. So where do I see it going? Maybe we'll have some sort of federal guidance on AI usage and liability and responsibility, but I don't think it's coming. I don't think it's coming anywhere near as fast as the changes in the technology are coming, which is kind of constant for law. It's like I always say, technology leads and then business kind of puts its sneakers on and runs after the technology. And then we lawyers show up with our push brooms and like clean up the mess that everybody left. And that has always been the way it's been, and it's not been any different so far because
Yeah.
the law is very reactive, right, to business and society.
Yes, I would agree with that. Wow. Wow, this has been great. Maria, do you have any other questions or thoughts?
Oh, this has been wonderful. Thank you.
Share,
Well,
Sharon,
you guys ask
anything
awesome
else?
questions, and you are great conversationalists. This has been a lot of fun for me.
Thank you
Thank
so
you.
much for joining us today. This has been helpful. If you want people to contact you, what's the best way for them to get in touch with you?
Well, first of all, Nicole, Maria, thank you very much for having me today. This was a great conversation. There's a couple places you can get in touch. Legalandcreative.com is our firm, my law firm, Toerek Law, which does business as legal and creative in the marketing world. Very active on LinkedIn, so find me there. It's Toerek. And check out our podcast. It's not legal, but we talk to a lot of marketing professionals about looking around the corner of marketing to see what the future might hold. And that's the Innovative Agency, wherever you listen to podcasts.
Okay.
Very good.
Thank
And
you.
I read the blog posts on her website are really, really meaty. You know, there's a lot of blog posts that are just fluff, right? Maybe they were AI created, but hers
Ours are
have
not. It was all
no.
100% human
I could
created
tell.
content on our blog.
Yeah,
Thank you.
I could tell you she has links to like official resources. She breaks stuff down. It's a very good blog. And I started listening to her podcast as well. And it's a fantastic podcast. So go check her out. Thank you
Thank
so
you.
much, Sharon. This has been lovely.
My
Thanks,
pleasure.
Sharon.
Thanks for having me.